So in England, in the years following the conquest, lawsuits could be decided through various sorts of proof, and it was often the court's decision as to the type of proof that would be required, ranging from, say, oral testimony to documentary evidence if documents existed, to the ordeal, often if there was no other easier way of deciding the case. And it seems that the Normans introduced trial by battle, judicial combat, to decide matters concerning land, so that might also be used. However, later in the 12th century, during the period of Angevin legal reform, the use of recognitions grew. So the recognition was a panel of 12 free men who were sworn to state what they knew about the facts in dispute, and this was used in various different types of assize, so various types of possessory assize, so assizes concerning dispossession, assizes concerning inheritance, and also the use of the recognition expanded to cover actions of right, so actions which were, in contrast to the possessory assizes, actions which were more proprietary, which concerned the deeper question of which of the litigants had the ultimate right to the land in question. In an introduction which has been associated with the Council of Windsor in 1179, the grand assize was introduced, which allowed a litigant, the tenant, the person holding the land, in an action of right to elect to have the matter tried by the grand assize. And here we have a panel not just of 12 free men, but 12 knights who had to decide on the facts in dispute. When Glanville talks about recognitors, he explains that they can be objected to on the same grounds on which canonical witnesses can be objected to, and I know you're going to talk a bit about that later. So certainly in the late 12th century we see a movement towards the judgment of recognitors, a form of jury in English law in civil matters. Most people tend to assume that the use of the jury in criminal matters is a product of Magna Carta, ordering that individuals should be tried by their peers or by the law of the land. But the addition of the phrase or by the law of the land meant that traditional modes of proof could still be used in criminal cases. And then at this time, the traditional mode of proof was the ordeal. So a suspect, if the jury of presentment, which functioned in a way a bit like a grand jury in the US, if the jury presentment declared on oath that a certain individual was suspected of committing a crime, they would be put to the ordeal. However, at a very similar time period to Magna Carta in 1215 again, the Fourth Lateran Council forbade the use of the involvement of the clergy in the ordeal, which stripped the ordeal of its kind of ritual, its sacral properties, and therefore as a mode of proof it became largely useless. So after a period of in which there was no sort of formal declaration on how criminals should be tried, a writ of Henry III in 1219 declared that a petty jury should be used. So it eventually took the idea of the jury of presentment, that suspects should be sort of declared by a jury, moved this forward and led to a jury deciding the actual question as well of guilt or innocence.
Yeah, as you said, the ecclesiastical courts mainly used witnesses in contrast to juries. And these could be eyewitnesses, or they could be witnesses testifying to things that were notorious, much like a presentment jury. And then there were various restrictions as to who could be a witness and who could give a valid testimony. So in practice, the total number of witnesses one could bring in an ecclesiastical court could vary. It had to be at least 2, but the canonical limit was 40, in fact. And then there were a number of ways in which you could determine whose testimonies would be used. So if a witness contradicted himself, then the testimony should be rejected. and if a group of witnesses agreed, then that testimony should be followed. If the judge had to choose between two parties that agreed internally but disagreed with each other, then he had to choose based on which one was least suspicious and fit the matter best. And then if none of this was possible, he had to decide based on those which were more trustworthy based on their social standing and relationship to the party. So you'd have freeborn over free, old over young, man of property over a pauper, noble over ignoble, man over woman, a friend of the defendant over his enemy. And if all the witnesses were of the same dignity and status, then the judge had to decide by number. And then, if they were the same in number as well, the judge should absolve the defendant. There were many people who were forbidden by law from testifying. These included the unfree, paupers, vagabonds, and the excommunicate, or those accused of crime. And proctors or advocates from the principal case, if the case was one of appeal, were also barred from testifying, as were servants, relatives of the producing party, or known enemies of the party against whom they were produced. Exceptions against witnesses, much like the exceptions that could be raised against recognitors, I think could only be raised after testimony was given. So no one was actually excluded from testifying, but doubt could be cast on the testimony after the fact. This was, a more expedient way to do things: postpone the exceptions until after all the testimonies are given, and then have a batch of exceptions that you would give. Parties would occasionally then also have trouble producing witnesses. Maybe someone was too old, too poor, or too ill to make the trip to court. It was particularly difficult to get witnesses to come to court in appeals cases because of the distance that was needed to travel. If key witnesses were unable to appear or refused to appear, actually, then the party could ask for the court to compel them to appear or threaten them with excommunication if they didn't. Or if there was no way that they could physically come to court, then they could send an examiner to that person to examine them there. Once a witness had testified, the opposing party couldn't ask that the testimony would be excluded at all. Rather, he would argue that no faith was to be placed in the person of the witness, which suggests the value of testimony was left to the discretion of the judge. And then, rather than depending on the number of unexceptionable witnesses in a case, I think the judge then would evaluate the testimonies in comparison with each other and then hold this kind of against the persons of the witnesses, the internal consistency, and the details when deciding who had the more convincing proof.
So although there are certain similarities between the use of recognitors, jurors, and the use of witnesses, they perform a very different function actually in the resolution of a dispute. So whereas the verdict of the recognitors or the jurors is the verdict of the court, witnesses in canonical proceedings provide evidence, yet it is the judge's weighing of the evidence of the witnesses which leads to the verdict of the court.
Yeah, the witnesses themselves don't do any of the judging, they're merely providing the details.